Please be seated. The court is now back in session. And again, we hand the floor to the defense team for Kieu Sampon to continue putting questions to Venerable Phuong. Counsel Kong Sampon, thank you, Mr. President. And again, good afternoon, Venerable Phuong. My next question is in relation to the time period that you stayed at Angkor Pagoda. You have stated about the fact that you were instructed to do labor, namely digging canals. Can you tell the court how many months were working or engaging in labor in your group? Answer. We were divided into different groups. There were 10 months or 20 months within a group. So we were organized into various groups, as I just stated. Question. Besides digging canals, what other work did you do while you were still in monkhood? Answer. I also engaged in planting cassava, rather. And also we grew vegetables. Question. Can you also tell the court that this kind of work, planting cassavas or growing vegetable, is it against the Buddhist disciplines? Answer. In terms of the Buddhist disciplines, it was wrong. For example, engaging in planting cassava or in growing vegetables, it violates the Buddhist disciplines. Question. You talked about violating the Buddhist disciplines. What kind of violations that you refer to in terms of being a monk and engaging in that kind of work? Answer. Monks were prohibited to engage in that nature of work. Question. Now, in relation to living monkhood, that is you personally, can you tell the court what was the process of living the monkhood? Answer. To live a monkhood and in order to become a layman, there had to be a witness who would see the whole process of living the monkhood. So that in terms of religion, it means that we would live the monkhood and we would become an ordinary person and not become mentally disturbed. Question. As for you, when you left the monkhood, who was your witness? Answer. There were other monks who were there. So we just be a witness to one another for the process, because we started to live the manhood one after another. My question to you is, to you personally, when you left the manhood, was there a teacher who disordained you or who made you live the manhood, or did you just do it by yourself alone? Answer: no, I left the manhood at the pagoda, not at a village house. Because we were monks, we followed the disciplines, and we had to do it in a pagoda. And at that time, the Buddhist statues remained undisturbed in the pagoda, and we did it before the statue. And we also had a witness to the process of living the manhood. Question: when you were living the manhood, can you tell the court who was actually your witness to the process? Answer: of course. It was my teacher monk, who was my witness. Thank you, says the counsel. Now I'd like to ask you on a point that you already stated before this court, that is on the different terms of living the manhood and of defrogging. We have the word Licha Sakabot in Khmer, which means to live the manhood, and the word Psak, that means to be defrogged, or Sak in Khmer, to disordain. Can you entertain the court on the differences between the three terms? Answer: to be defrogged or to live the manhood means we simply leave the three statutes of the Buddhist disciplines, that is the monks, the Buddha, and the disciplines. We leave them all behind to become a layman. As I said earlier, simply in the end, it means a monk becomes a layman, or an ordinary person, by whatever means you use. So when you live the manhood, or when you defrog or disordain, there is no clear discrepancy. As in the end, you become a layman or an ordinary person. Thank you. Question: if I add a word that a monk was forced to defrog, would it be different from what you just stated? Answer: if somebody uses an authority to force a monk to defrog and to become a layman, and that what happens during the Khmer Rouge regime. They use the authority to force the monks to live the manhood. So monks could not stay as monks, and that's the nature of their revolution, and that we had to engage in labor, as I stated earlier. Question: this morning you also stated that you knew Kilno. Do you recall that? That before 1975, that a man stayed at the Mahamantri Pagoda? Answer: yes, he was a monk and he resided at Mahamantri Pagoda. Question. How long had you known Kilner as a monk? Answer. I knew him because we stayed at a pagoda in Phnom Penh together, but I did not know how many years had he been ordained as a monk. Question. I'd like to read a statement of Kilner. That is document E1.90.1 at 9:30:15, which is a transcript dated 21st March 2012. And allow me to read you this portion. Free translation. Quote, we cannot say for sure, but it was about 1 or 2 years. I apologize, Mr. President. I'd like to readjust my document first. Council, it was at 9:38:24. It's the same document. It's a page over in the Khmer language. And let me quote. Answer. No, I didn't know that. I didn't know about the Cham people. I became aware of that. No, I was not. And as they were forced to be to defraud, no, it did not happen that way, but we were told to leave the monkhood. So the word forced to defraud was not used, and I never heard about it, and I never saw it. And my question to you is the following. What would you react to this statement of Kilner? Answer. That is his personal account, but I have told the court about my personal account. Question. What would you like to add to the word to to be forced to defraud or to leave the monkhood? Answer. Allow me to clarify. If somebody was forced to defraud, it means somebody would physically come to force the monk to leave the monkhood. And another difference is that we were instructed to leave the monkhood, and that we engage in the process by ourselves because we understood that we could no longer stay in monkhood. Thank you, says the counsel. Question. And in your account, as you left the monkhood, and as witnessed by your teacher, can you explain to the court was the process considered a forced process? Answer. Of course, we understood something had happened, and as we should understand the cause and effect of the process. If we understand that, we know whether it was forced or not. President interrupts, and counsel, please move on. Counsel, thank you. Question. can you tell the court after you left Ongroka Pagoda, where did you go? Answer, I went to Bantiai Mir district in Cambodia province. Question, can you give a bit more detail? Answer, it was a Samrang cooperative, Bantiai Mir district. Question, did you remain living there or did you move elsewhere after that? President, when in a roll, please wait for the microphone's activation first. Answer, it was a village, but in fact I was constantly in a mobile unit as I was part of a main force, and I was on mobile until the liberation of the country. Question, when you were in Bantiai Mir district, was it Bantiai Mir or Tuk Mir? Answer, it's a Bantiai Mir. Question, did you, for instance, relocate yourself to a different village or a different commune within Bantiai Mir district? Answer, no, I did not. Question, you also stated before this court the term Angka repeatedly. For example, when you were called to a meeting, the meeting was organized by Angka. And in terms of your personal knowledge, when you refer to Angka, what do you mean? Answer, at that time I didn't know for sure who Angka was. Everybody talked about Angka, but nobody ever saw who Angka was. And when we were assigned tasks to do, we were told that it was planned by Angka, or it was followed the instructions of Angka. Question, did you ever discuss or ask what or who Angka was? Or whether Angka was someone in charge? Answer, at that time, yes, I asked where was Angka and who was at the upper echelon. I asked the people about the Angka and about the upper echelon, but the reply that I received was that Angka was the upper echelon, and they warned me not to ask too many questions about Angka, and that we only should know about Angka, and that's the limit. Question, for you personally, what is your understanding of Angka? Answer, it is a word commonly used during the regime, that is during the Pol Pot regime. And we did not know who was or were Angka. And they talk about the Angka Macham, or the organizational center, or the Angka's center, and the instructions came from there. Because we asked each other about the Angka and about the instructions from Angka, and the only thing we learned was that the instructions came from Angka, which was at the upper level or upper echelon. Council, thank you. Question, When those people spoke about Angka, did they refer to themselves, for example, the commune chief or the cooperative chief, or those people who made contact with you, did they say that they represented Angka themselves? Answer: I was only told that Angka means the upper echelon, and that was it after I made inquiry with them, and that the orders or instructions came from Angka. And of course, as I stated, we didn't dare to answer more questions. Question: what did you understand of the word secret, and did you keep secret or keep to yourself? What can you tell us about secrecy? Answer: Counsel, please repeat your question. I don't really get it. Question: you stated that you did not dare ask many questions, and my question to you is that did you hear about the principle of secrecy? And did you actually abide by such a principle of secrecy during the decade period? Answer: I still don't get your question, Counsel. What do you actually want to ask me? What do you want me to say? Question: I'd like to ask you in general. For example, during your contact with other people, or with your peer, or with the cadre, Sakmarus cadre, could you make such a contact freely? Answer: during the regime, such contact was very rare. Even the contact between our family members was very rare. We didn't even dare to speak to one another. And here I frankly speak. At night time, we did not even dare to talk to one another. And during the working hours, we just kept on working. And we didn't dare to take time to talk to one another, and that's what was the common practice during the regime. If we talked more, it means we would be in a risky situation. And if we pretend to be silly or to be stupid, then we could survive. Counsel, thank you, Venerable, and Mr. President, I don't have any further question. President. Venerable Am Prương, the Chamber is grateful of your time to come and testify before this court during this one full day, and your testimony will contribute to ascertaining the truth in this case. And now the time comes to the conclusion of your testimony, and you may be excused so that you can return to your place of residence. And court officer, in collaboration with WISU, please assist in the arrangement of transportation for the Venerable to return to a pagoda where he resides, or to whichever place he wishes to go to. You may now go, Venerable. And Counsel Coupe, you have the floor.
Thank you, Mr. President. Because we still have half an hour to go, rather than rather than revisiting the issue of this morning tomorrow and take away time from the other parties to examine the witness of tomorrow, I would like to refer to the email that we received from the prosecution this afternoon in relation to case 4 documents. The prosecution, the deputy co-prosecutor, wrote to you and to us that in addition to the earlier statements from case 4 and the 20 statements that we just received this afternoon, there is another astounding number of 89 and 190 documents to be coming from case 4, documents to be added to our case. 89 and 190 plus the earlier ones make a total of 334 documents from case 4. We were able to have a very quick glance at the 20 case 4 statements that we received this afternoon. And what we could see, and I just have a very brief summary, a very brief indication. It seems that one witness can testify about the leadership of the Tram Kok district. One witness possibly can testify in detail about a former secretary of District 105. One of those witnesses was a chief of a commune in Tram Kok and possibly could testify about several immediately upcoming witnesses. One was a Tram Kok district messenger and can apparently testify in great detail about an upcoming cadre witness and about delivery of messages to communes in the Tram Kok district. And it seems that at least one witness within those 20 statements, witness statements, is a surviving prisoner from Krang Tachan, and allegedly the child of that prisoner was killed at Krang Tachan. Now, I think we can all agree that these are very relevant statements for also the upcoming witnesses. So this, in combination with the fact that we are awaiting at least 270 more documents in this phase of the trial, I'm not quite sure what words to use to describe this, but I'm not sure how to deal with this, but it seems that the only real possibility in order to be able to conduct a proper defense is to ask for postponement and to receive all those 270 documents in order to be able to establish what the relevance is. If we continue like this and we just get the documents hand by hand or in small numbers, by the time we have them all, we might have to recall witnesses. I don't know exactly if that would be a proper way of acting. But the way it's going now is, in any case, in stark contrast with what the prosecution said earlier, that it is a small number which is coming. But the total of 334 documents, as I said again, it's very disturbing. And I think we should have a proper debate about what to do with this.
President, you may now proceed. Counsel for me, Mr. Kil Sampon, Deputy International Co-Prosecutor, you may now be seated. Wait until other party completes their observation and submission, and after that we will hear from you, and the chamber will decide after we all get all information.
Yes, Mr. President, thank you. I perfectly support, as this morning, my colleague, and also I would like to state our concern. As I said this morning, we have here a real problem in terms of interpretation of what may be considered as relevant with regard to the documents for the witnesses who will testify soon. It's not because the documents do not particularly refer to one specific witness that these are not relevant documents, because it's obvious that when several witnesses speak about the same place and about the working conditions in working in cooperatives or in security centers, well, For us, it is the confrontation of these different testimonies which will make it possible to enrich the discussion here before the chamber. So given what my colleague has reminded us of, and as was said by the civil party lawyers, but for us as defense lawyers, we need to have visibility on the documents that are going to be part of the case and that are going to allow us or not to question the witnesses to come. So we're asking the chamber to find a quick solution, because there are still witnesses who are going to testify about Kreng Tachang and about Tram Kok who are going to come, and the documents as they were produced today, which of course we were not able to see in detail. This of course requires time. It is obvious that this is going to have an impact on the preparation of the witnesses to come, and if we want to save our resources, well, we shouldn't have a witness come back because he has to be confronted with new documents. So maybe the solution would be to postpone the testimony, or that time be given to the defense. But if the civil party lawyers do not feel that this time is necessary, but we feel that we need this time to properly prepare our defense.
President, you may now proceed. Counsel, in addition to the request from my learned friend, my colleagues, I would like to mention our difficulty in familiarizing ourselves with the case file in cases 03 and 04. Actually, we, the council, have no access electronically to some of the case file in those cases. And we received only one copy of the documents that we have received, and we cannot make copies because it is very confidential. And whenever we have received more and more documents, particularly hard copies of the document, it causes complications to counsel. Once again, in addition to the request of my colleagues, I request the chamber to be flexible so that we can have the access electronically to the case files and we can have relevant information. President, Judge Fen, you may now proceed.
Before the prosecution rises, I have a question which they might wish to answer when they give their comment. In the email referred to by the defense counsel, it first says that a submission which kind of clarifies things further will be filed on Monday, 23rd of February, and secondly, it mentions the further 89 statements which will be disclosed shortly. Now, will this email tell us what exactly shortly means, or will you today be in a position to do that? When it comes to the other 190 mentioned, I think in the last paragraph, my guess is, but it's also a question, that currently you're not able to tell us when they will be released and how. Is this a batch of 190 then, or are they coming, I don't know, in installments? Are you able to answer any of those questions now? I understand that this might be what you actually plan to do on Monday, but...
Thank you, Your Honor. Indeed, we would like to clarify once again the process which we are involved in, and I wish to say to everyone that this is a difficult task for the OCP to have to, with regard to each lot of documents to forward them to the parties. We are obliged to perform 4 or 5 different motions before you can receive these documents. Now, with regard to the figures that were given to you, I'd like to insist upon the fact that among the 89 statements which we asked the co-investigating judges to have the leave to share them with the parties and with the chamber, there are only 2 that involve Kramkak and Krangtachang. And among these 89 statements, there are none which regard the witnesses on your lists. That is to say, the people who are selected for this first segment. Now, with regard to the 190 documents, we, of course, don't have everything in our hands. We are asking to read the documents when we receive them and to see which documents should pertain to case 00202 and which documents may contain exculpatory evidence and therefore could be useful to the defense, and therefore then we ask the investigating judges to have leave to forward these documents to the different parties. The investigating judge and his team analyze our requests. Sometimes they do not accept them directly for reasons of secrecy, so there is a delay that sometimes can be rather long. So what we do is that we prioritize the documents by drawing the investigating judge's attention on the fact that a certain number of topics are being considered by this chamber during the hearings, and therefore these statements should have priority. It should be given priority by the co-investigating judges. So we cannot say when these 190 statements will be available to you. We, of course, have no control over the schedule. What's sure is that each time we receive, and this is quite often, new written records of interviews, of witnesses with reference to the 2 other cases, we read them very, very quickly. Of course, we have many, many other things to do, so we do as best as we can. We read them in Khmer, we read the translation when the translation is ready, and each time we very quickly ask the investigating judge for permission to transmit these to you, because we're always in a very tight situation. And the co-investigating judges also have their obligations. So in certain cases, they tell us that we have to wait for other people to be interviewed before they can accept our request. Now, maybe reacting to what was said by the defense, which is pretending to be surprised by the number, I wish to remind you that in our document E305/13, that's the list of the relevant documents to case 00202, we said as of June 2014 that there would be at least 267 witness and civil party statements in cases 3 and 4, which at one given moment will be placed on the case file because we believe that these statements are relevant. So I believe that the parties knew already for quite a while what the situation is, but the problem for us is that we do not get authorization very quickly from the co-investigating judges. So I also would like to underline, with relation to this figure of 267 that we announced, is that every month there are about 30 extra written records or interviews that are placed, that are gathered by the co-investigating judges and that are placed on a case file, which means that there are more than 267. And this is why we are arriving now at a total of around close to 300 documents. So this can be explained by the fact that we're under a continuous obligation and the written records of interviews keep on arriving, so we're obliged to react the way we do. So therefore, we object to any delay regarding any postponement regarding the trial. We understand the parties' concerns. This puts on us an extra workload. The only thing that I can say regarding segment 1 is that with the 20 statements that were given to the parties at the end of last week or this morning for certain parties, we practically have all of the documents that regard the first segments, and there are 2 extra for which we're waiting for leave to communicate these. So we have to understand that this is not our choice to not forward these documents. We do it as soon as possible and in such a way that everyone can be prepared in the same way. Now, with regard to the fact of not having access to the electronic documents, the international co-investigating judge therefore put conditions, so it's not up to the trial chamber to decide whether or not it will be possible to have access to these electronic documents, but only the international co-investigating judge. So pending the end of the investigation, that is the only solution that we have now. And we are obliged to abide by the confidentiality obligations given to us by the international co-investigating judge. Thank you.
President, lead co-lawyer, you may now proceed.
Thank you, Mr. President. Simply to go a bit further in the clarification of our position, we understand perfectly well the defense's concerns, and we will rely on the court's wisdom, as we say. Of course, we want to express our own concerns. We have asked for a long time for an expeditious trial, so we believe that we are able to move ahead and to manage the information that is sent to us by the prosecutor. But simply so that the other parties may understand our position, we, co-lead lawyers, do not have access to these documents because we have no mandate in cases 3 and 4. So some of the lawyers with whom we are working have also civil parties in cases 3 and 4, and in that case they do have access to the documents, but they do not have the possibility of giving these documents to us. So we are exactly in the same situation as our colleagues at the defense. We discover the written records when they arrive before us, and I haven't even looked at the folder that was given to me over lunch. So therefore, I'm going to rely on the chamber. For me, the true difficulty regards the 20 records we received today and not the 89 and 190 written records that will arrive later, because then we will be able to manage them. But with regard to the 20 that have a direct impact on the next segment, I will simply ask you to wait for clarification from the co-prosecutor's office on 23 February in order to allow the parties to answer this filing for clarification coming from the co-prosecutor's office. So our position is the following. We object by principle to a new postponement of the hearings, and we ask you not to take any decisions before you have received the written clarification from the prosecutors that is expected on 23 February. Thank you.
President, Mr. Kope, you may now proceed.
Thank you, Mr. President. Just a brief response. prosecution hasn't addressed the question as to when we are, for instance, supposed to read those 20 statements. I would like to get some sleep tonight, so I don't think I'll be able to read those 20 statements before tomorrow. It seems, by the way, that one of those 20 statements is a statement dating August 2013, so I really don't see why we had to wait so long to get that statement. Monday, I think, waiting until Monday is too late because I believe Wednesday or Thursday relatively important cadre is coming to testify. So he possibly might need to be confronted with the statements or the content with those 20 statements. So I think waiting until Monday until the prosecution comes with something is too late. And the last remark I would like to make is that we are pretending to be surprised. I don't really see where that comes from. I specifically, and that's why I quoted that passage from the transcript, I specifically asked the prosecution, what could we expect? And he said a pretty small number. Now maybe he and I differ in what a pretty small number is, but certainly not almost 300. So I think I don't really see how we can proceed with witnesses this week.
President Judge Fan, you have the floor.
Obviously, it's a big issue, and we have to think about that. But to organize the next days, if I understand at least Councillor Fonancio correct, he doesn't see a problem for tomorrow. Is that okay? Can we have an agreement on that?
I think
ideally?
Ideally, tomorrow shouldn't be a problem, but
okay.
But the next one, yeah.
Yes. Yeah. Do Councillor for Krisampang agree for tomorrow? Yeah. Yeah. Okay. And but you think the Wednesday witness, from your perspective, might be touched by this?
Oh, again, it's a very preliminary reading, just going through the first 20 statements, and it seemed to be having an important impact or relevance to Wednesday's or Thursday's witness. So, but we just glanced through it, so there's nothing more that we can say right now.
President, Deputy International Co-Prosecutor, you have the floor now.
Just a little point of clarification, Mr. President. There may be indeed statements dating back quite a while, but in reality, this is explained not only by the necessary delay from the co-investigating judges to give us the leave, but also because some of these statements are not notified to the parties before a certain delay, probably also for reasons of confidentiality. So a statement of 2013 was not necessarily notified in 2013. Sometimes we might have to wait several months or even longer. Now, when Lysak spoke about a small number of statements, I sincerely believe that he was referring to the first segment of the trial and not to the rest of the trial. As we said in June 2014, we already announced that there would be 267 statements, and I told you this morning, with regard to the second segment, we are waiting for the leave to communicate to you 60 statements that relate in particular to the Trapentmo Dam. Thank you.
President, thank you very much. Court officer, you are instructed to usher in witness 2 TCW 934 into the courtroom.
សួស្តីលោកសាក់សី
President, good afternoon, Mr. Witness. What is your name? Answer, Mr. President, my name is No Yao. Question, when were you born? Do you remember your birth of date? I was born in 1947. Question, thank you, Mr. No Yao. Where were you born? Do you remember? Answer, I remember that I was born in Pioneer Village, Samraung Commune, Tramkot District, Takao Province. And what is your current residence? Answer, my current residence is in the same village, commune, district and province. Question, what is your occupation, Mr. No Yao? Answer, I am a rice farmer at Angtama Pagoda. Question, what is your father's name and what's your mother's name? Answer, my father's name is No Cheng, my mother's name is Riem Chuan. They are all deceased. Question, thank you. What about your wife? What is her name and how many children do you have? My wife's name is Sehran. We have 5 daughters and 1 son. President, thank you, Mr. No Yao. Based on the report of the greffier, to the best of knowledge, you have no parents, ancestor or descendants who are admitted to this case. Is this true? Answer, that is true, Mr. President. Question, have you already taken an oath before the iron statute to the east of this courtroom? Answer, yes, I have already taken an oath, Mr. President. President, thank you, Mr. No Yao. You are now informed of your rights as a witness before this chamber. As a witness in this proceeding, you can refuse to answer any question or you can refuse to make any statement which incriminates yourself. You have the right not to make any statement which is against yourself. That is the statement that can lead to prosecution against you. As a witness, Mr. No Yao, you have to give testimony before this chamber. You have to respond to all questions put by parties or by the bench. Unless your answers may resolve to may lead to incriminating yourself. As a witness, you are required to answer to your knowledge about your personal experience, what you see, what you hear, what you heard. In relation to the facts, Mr. No Yao, have you ever gave statement to an investigator of the OCIJ? And how many times, if you have, how many times have you given to the investigator of the OCIJ, and where was it taken place? Answer. I gave statement once. It was at my home. When was it? Question. Said Asa, Mr. President. Answer. I forgot the year. Question. Never mind, Mr. No Yao. Before you are here in the courtroom, have you already reviewed the statement made by the investigator of the OCIJ already? Answer. Mr. President, I have reviewed the statement and I have recalled some of my statement because the interview was taken a long time ago. Question. Have you read the statement before you are here? Answer. I have reviewed the record of interview, but I do not recall them all. Question. To the best of your knowledge, in relation to the statement you gave to the investigator of the ECCC, does the statement reflect what you have provided to the investigator? Answer. Yes, it's correct. The statement that I gave to the investigator, it reflects what I have given. President, thank you, Mr. No Yao. Because we do not have much time, so I only put some question in relation to your background. And the chamber does not yet hear the substance of your testimony, so you are invited to be here to provide a testimony before, and which will start at 9 a.m. So your testimony perhaps will be concluded in just one day. It is now time for the adjournment. The court hearing will resume tomorrow on the 17th February 2015, starting from 9 a.m. And tomorrow we will hear the testimony of witness No Yao. Please be informed. Court officers, please facilitate with the vessel to send the witness to his preferred destination and have him return in the courtroom at before 9 a.m. Security personnel, you are instructed to bring the two accused back to their detention facility and have them returned tomorrow morning before 9 a.m. The court is now adjourned.